Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
All right, and we are back. We are back for part 4. Now, let me make sure y'all can see my copyright disclaimer. Let me go ahead and get that back up, and also my QR code to my X page, top left-hand corner of your screen. Now, disclaimer. There will, probably will be a word that I will stumble upon. Bear with me. It is not that deep. Okay, let's continue. And that has the standard questions. I don't want to tailor the questionnaire form to the case. It makes it longer and more unwieldy. Mr. O'Sullivan. Okay, the court, any other issues? Ms. Dixon, are you saying we have to agree on our submissions, individual submissions to the voir dire questions, or the court? No. Each side will submit proposed voir dire questions, and I review them and I incorporate them into my own conversation with the panel. I may or may not ask all of those questions. And as I said, you each have time after I'm done, and you can follow up with some that I may not have touched on or any other matters. Ms. Manillo, Your Honor, one question on the voir dire. Would you like the parties to submit them to chambers or on the docket? The court? On the docket. Ms. Manillo, thank you. The court? Yes. Anything else? Mr. O'Sullivan, not from the plaintiff. The court? Ms. Dixon, any issues on your end? You're muted, Ms. Dixon. You're muted. Ms. Dixon, sorry. I think we can resolve some of the witness issues later, but I had just gotten a report. I've gotten like 2 reports from experts, one on the medical records and another one on the digital forensics. And I would need them to be able to come in to explain the digital things that they have, because they have a lot of digital evidence. So, and then the medical records. I have some issues with those, because the issue here is whether, truth is the ultimate defense to defamation. And there are some discrepancies in the medical records that I've had to have those reviewed by an expert, an emergency room doctor who's an expert, and another expert that deals with a nurse who's an expert who deals with charting. There are some irregularities in the charting of the medical records that were presented to me. They were actually presented late. They were directed at Megan's deposition. And it took me a while. Originally, I wanted to depose the doctor, Dr. Milton Little, who allegedly did her surgery. And unfortunately, his office is closed and he's left. Period. I mean, there's no forwarding address or anything, so I can't do that. So I need to have an expert review the medical records. So I have those information. I just sent over the digital forensic report, but I also have, it's only like a 2-page, maybe 2 or 3-page report from one expert and another one that's maybe, it talks about the disparities in the medical records. So that's the only issues I have. And we have a very short witness list, actually, compared to theirs. Mr. O'Sullivan, as to what was just disclosed today about the experts, that's the first we hear on any of that. Most of the deadlines have passed. I don't want to react in a moment. We'll see what it is, but we're going to stand on our rights. We've prepared our case, and none of this was disclosed. And our client has kind of paid a heavy price for the other side's sort of self-serving approach to the schedule. And doing out of time now will be prejudice. But we'll see what they send. But this is all news to us. Ms. Dixon, actually, Your Honor, they were very late in producing evidence to us, and we didn't realize that it hadn't been produced previously. But when speaking to Michael Pansier about something else, he mentioned that most of their discovery was Oh, I'll provide it later. And as you can see on the docket, they provide some on August the 1st, which was the actual deadline. And then they provided some attorney eyes only. We didn't have access to it until the day of meganpete's deposition, but we didn't make it an issue and say, oh, we want to redepose her, like they did with milagrogramz. But we received a substantial amount of information either the night before or the day of the deposition. So I did alert them on that, well, to that. And they gave me permission. Megan signed off on a medical release to me to get the medical records directly from Cedars-Sinai. It was quite a process to do. So I have discussed that with them and I've had them reviewed now that I have actual copies. The copy that we had was from the trial, and it was actually not authenticated. And since this is an issue in the case, I am entitled to have, I don't know why prior counsel didn't subpoena the records, but I'm entitled to have an authenticated copy because you can't lie or lay the foundation for even presenting that evidence without having an authenticated copy. There would be no foundation. So I needed something from the custodian of records from Cedars-Sinai, and that apparently wasn't in the trial. The trial transcripts were not the transcripts, but the Bates stamped information that the district attorney used in the trial was not authenticated, and there was no foundation. The court, I'm not sure why it is you're bringing these matters up at our pretrial conference, Ms. Dixon. Note that the operative scheduling order entered back on April the 2nd required that all expert witness summaries and reports be exchanged by June 27th. Rebuttal expert witness summaries and reports were due by July the 11th. So June the 27th, summaries and reports be exchanged, and then July the 11th, rebuttal expert witness summaries and reports were due. Okay, let's continue. And those dates have long gone. So I don't know what it is you're referring to about your review of medical records and some folks who you call experts. You can certainly have consulting experts. Every party is entitled to that. You can have experts assist you in your review of records and in your preparation for trial, but these will not be testifying witnesses if you did not properly disclose them as required in the scheduling order. But that's Ms. Dixon. So, Your Honor, they deposed, I'm sorry, the court, yes, Ms. Dixon. They deposed meganpete. I received these on July the 30th and August the 1st. That's when I received this information. And so that was after the time to designate experts. You said July the 11th. It was July the 30th. And I didn't have this information until July the 30th. The court. So, as you are aware, Ms. Dixon, it behooved you to file a motion under Rule 16 of the Federal Rules of Civil Procedure, requesting an extension of the scheduling order's deadlines in that regard. And I don't believe you did so, ma'am, Ms. Dixon. I believe we did, and the court denied it. The court has, every time we've asked for an extension, the court has denied it. The court, Ms. Dixon, I have, in fact, entered orders denying requests under Rule 16 where I found them not to be well supported under the standard that applies. If I denied that, ma'am, in this case, then that means that you are out of time for using some experts now at trial that were not timely disclosed. Ms. Dixon, okay, the court, all right, Ms. Dixon. Yes, but I do want to put one thing on the record. Every time the court denies the motions, they always cite that April 11th prior counsel got an extension. Just really don't feel, in a sense of fairness, that applies to me and Jeremy simply because we did not enter this case until June the 6th. And so many of the deadlines had already passed. My client was in pro per, and most courts would give an extension when you have extensive evidence, as this is. There's an extensive amount of evidence. They hired 11 attorneys just to go through her computer and her phone. So that is something that we weren't able to do. And we already had an extensive amount of evidence to review once we were finally able to get the drive from prior counsel and open it. So, and we've had these ongoing discussions with the plaintiffs, and I don't believe there's any undue prejudice to them. But I do believe, but I believe that that the purpose of this whole exercise and this whole complaint is to affect this man's appeal, because he has a direct appeal that was heard on August the 18th, and it is due by August the appellate court has 90 days, and they will be making their ruling on or about August the 18th. I'm sorry, November the 18th, on or before November the 18th. And I just believe that this case was just an attempt to affect his appeal. And I don't feel that there's any undue prejudice to the plaintiff to give us a little bit more time. They're already talking about, as we speak, Your Honor, there's been emails back and forth that I've seen between Dan Humphrey and the court, the magistrate judge, to have another deposition. They deposed 2 people. They deposed my client. They redeposed her last week. They deposed Livingston Allen, DJ Academics, just a few days ago. And now they propose to depose Tory Lanez in the prison on November the 14th when the trial starts on November the 17th. I feel that's unduly prejudicial to us, and we won't have any of those witness designations that they want to use prior to trial if they're going to go in and do that on November the 17th. So I just feel like there's a bit of double standard here. You can't just say, let's push the gas. It's unduly prejudicial to my client, and yet request that the court give them the ability to continue to depose people up until the day. I mean, the 14th is literally the Friday before the trial starts. So I just don't think that's reasonable at all. And we wouldn't have any time to prepare for anything that has to do with that particular deposition. The court has also expressed the due to the government shutdown. There's some issues regarding staffing at the court. I don't feel that this is reasonable at all not to give an extension. There are several different reasons. There's an actual government shutdown, which causes impracticability or impossibility of performance at a certain point when you have such low staff. But I don't feel that it's fair that they keep saying, let's go, but that let's make an exception for us. Because if there's no exception for, then there shouldn't be any further depositions. We have closed everything. We need to just go to trial with what we have. That's the only fair thing to do. It should be applied equally against both parties, because what I'm seeing is things are applied against me and Jeremy and my client that are not applied against the plaintiff. And I just have to call it out. I just have to say, I don't think that's fair. And I want that on the record. The court, the government shutdown and court staff being furloughed or exempt in no way has affected the schedule in this case or your work as lawyers in getting trial ready. Let me make that clear. The government shutdown will not affect our ability to bring jurors to you in the courtroom and impanel a jury to try this case. It will affect jurors' receipt of pay for their work, as they won't receive it timely. They'll receive it later than is customary. That is the only way that the government shutdown is affecting this case. So it does not affect your clients. It does not affect the lawyers who are required to work with diligence to meet a scheduling order deadline. I previously granted the defendant a 60-day continuance of the scheduling deadlines. I denied a later motion that sought some additional time thereafter, finding that the defendant's attorneys had not shown the required diligence. I don't know about additional depositions that are being taken. I know that you all had a number of hearings before the magistrate judge who has been handling that aspect of the case and is intimately familiar with the reasons why. Is there anything else? Mr. O'Sullivan, not from Ms. Dixon. Yes, Your Honor. I think it's unduly prejudicial for them to have a deposition on November the 14th when the trial starts on November the 17th. They also are seeking to schedule another deposition sometime between then and now. And, they don't. I have someone that I have served and that I want to compel the deposition, Detective Ryan Stogner. I'm sure they're going to, that's also in the night. That's also in the United States Court in the Central District as we speak. And I was going to do an ex parte motion to advance that hearing because the scheduling of that is on the 14th. And I believe that the Central District gives more time for deposition subpoenas than they give 14 days as opposed to the 10 days in the Florida jurisdiction. So personally, if there's a cutoff, there's a cutoff. If it's being applied to my side, it should be applied to their side. And they're still doing depositions. They even just redeposed my client just a week ago, maybe less than a week ago. And they deposed DJ Academics again less than a week ago. And so now they're also back and forth. While we were talking on this record, Dan has been sending back and forth to Judge Reed that he wants to have Aiden Ross deposed. And they've been agreeing while we were talking on this particular Zoom call. They also have been going back and forth about dates for Daystar Peterson. And they've agreed on November the 14th, which is the Friday before the trial starts. Mr. O'Sullivan, just to point that out, Rhonda, we were given the date that you gave us. Miss Dixon was the best in peace for getting Tory Lanez's deposition done. And she finally told me, I believe last night, she couldn't do it 7th. She couldn't do it in earlier date. It could only be the 14th. And that's why we noticed it that day. It's an equal burden on both sides, but it's a small deposition. We have to get it over. It's a crucial witness. Ms. Dixon, I actually told you that the first time you mentioned the 7th or the 14th. I told you on the 7th, I had something to do. And I fired an email right back to you just that day. So it wasn't yesterday. It was Crystal Morgan that came in yesterday and said that she would be available. That was the issue. That was the missing piece. And she's his attorney. The court, all right. It's highly unusual, at least in the Southern District of Florida, to have lawyers just chatting back and forth while I sit up here on the bench. That's not customary here. Mr. O'Sullivan, apologize, Your Honor. The court, not a problem, Mr. O'Sullivan. Ms. Dixon, apologize, Your Honor. The court, anything else? Ms. Dixon, no. The court, very good. I'll see everybody on November the 10th. Mr. O'Sullivan, thank you, Your Honor. The court, you all have a good day. Ms. Dixon, thank you. Proceedings adjourned at 1:41 p.m. And that is the end of the transcripts. Basically, what this is just an index. All right. We have gotten through the actual transcripts. What do you guys think about what happened in this pre-trial conference? The next conference will be literally on November the 10th. What do you guys think? Leave your comments in the description box below. Like, share, and subscribe. I just want to say I thank everybody. I looked up and I am at 700 subscribers. So I thank everybody. 300 more and I'll be at 1,000. That's what I'm shooting for. But I just want to say I appreciate everybody. And as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. I'll see y'all in the next video. Take care.